Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. On Tuesday, the Supreme Court heard a case called Groff v. DeJoy. Louis DeJoy is the postmaster of the U.S. Postal Service, and Gerald Groff is an evangelical Christian who left under pressure and discipline after requesting not to work on Sundays because of his religious beliefs. Why this is a federal case is that the Civil Rights Act says that employers cannot discriminate based on religious observance unless accommodating the religious worker would cause an undue hardship. And so this case is about what the bar to prove undue hardship is. In 1977, a case called Hardison, the Supreme Court said that anything that was more than a de minimis cost would be an undue hardship. And let's start with a clip of Justice Samuel Alito, who seemed skeptical of that precedent.
General, I'm really struck by your statement that regardless of what Hardison says, for the last 40 or 50 years, the EEOC and the lower courts have interpreted the decision in a way that properly respects the rights of minority religions. I'm really struck by that because we have amicus briefs here by many representatives of many minority religions, Muslims, Hindus, Orthodox Jews, Seventh-day Adventists, and they all say that that is just not true, and that Hardison has violated their right to religious liberty. Are they wrong? They misunderstand what the lower courts and the EEOC has done?
On the other hand, there seemed to be some skepticism or maybe concern, even from some of the court's conservatives, if the Supreme Court overrules that precedent about what kind of standard for hardship would replace it. Let's listen a bit to Justice Amy Coney Barrett.
When you say affect the operations of the business, that doesn't sound like, I realize you're saying morale isn't enough, but affect the operation of the business. Give me an example of when the effect on coworkers would do that.
Well, when a coworker quits would be an obvious example.
Quits because of morale. So it's just like morale has to get so bad. The employer has to wait until morale is so bad that employees actually quit.
Alicia, what's your read of this case?
So I actually had some conflicting thoughts on this. The justices definitely did too. I think the Hardison precedent was erroneous, saying a de minimis cost is an undue hardship or the same things, and they're clearly not. But part of the problem seems to be also how the lower courts are interpreting Hardiman, and then maybe they're being a little too strict here too. The other reason I'm conflicted here is I think the USPS initially did try to make accommodations for the worker here and attempted to do so several times until it just became too difficult. I mean, he actually had moved to a rural area. Just to backtrack a little bit just on the case, USPS started requiring that workers work Sundays when it got a contract with Amazon, and that he believed that essentially violated the Sabbath, and he did not want to work Sundays for religious reasons. And so the USPS did try to accommodate that in numerous ways. And when it couldn't, he moved to a rural area. Now, maybe I'm just purely speculating, but it's very difficult to actually find workers in rural areas and probably to deliver the mail. And so USPS may have said, well, this is now an undue hardship. We can't get workers to fill in for you. And now workers are quitting. And so now we have to fire you. And so I think this case may not be the best case to actually test Hardison, the 1977 precedent, but I do think that it was wrong, and there needs to be either some kind of other test or standard to replace it that's much more clear for lower courts to navigate.
So what Groff wants, what he suggests the standard should be, is that in order to get an undue hardship exception to this discrimination law, the employer should have to show that any accommodation would be a significant difficulty or expense in light of its size and operations. And so, Kim, the way that I understand that is what he's advocating is a standard that would be pretty fact bound. And a lower court or a jury would have to decide if this is a small business that has just a handful of employees, whether giving one of them a day off would be a significant burden, might be different than if it's a huge operation like the U.S. Postal Service. I think this is an important case. It bears watching for employers. Most of these kind of accommodation requests, you would think and you would hope, would be hashed out by bosses who are trusted by their employees and employees who are valued by their companies. I mean, there are always going to be some that land in a court. But I also think that it's worth pointing out, as Justice Alito says, there were all sorts of briefs that were giving examples of accommodations that were turned down, and to me look less burdensome than a postal worker who wants a Sunday off. So the Sikh Coalition, for example, says that there was an IRS employee who asked to carry the Sikh ceremonial dagger. It was about 3 inches and dulled, and was denied that request. And she says that there were other objects in her workplace, like scissors and box cutters, that were clearly more dangerous than this ceremonial Sikh dagger that she wanted to bring with her. But that was denied. And so that's an example of something where, Kim, you can imagine a jury hashing this out, or a judge hashing this out in the lower courts and saying, you know, I get that you have a policy against people bringing those kinds of things, but this is really not a significant burden on your business. And so that exception might be denied.
Well, I agree that it would be the best world if these things could get hashed out between an employer and an employee. Unfortunately, that is not the case, which is, of course, why the language here matters so much. And I think I'm kind of with Alicia on this idea that this may not be the best case to have brought given the particular circumstances here. And then the request, as you said, is really kind of swinging the pendulum in that right now the issue is the 1977 language, undue hardship, more than a small cost. But this seems to be a request to go very much to now it has to be something major. And for a lot of businesses, I get your point that one of the qualifying aspects of that would be based on a company and its size and its position. And that would at least be, I think, a little bit more definition to what has been such a vague reading up until now. But vastly expanding this, I think, could also put some really undue burdens on corporations if they start getting flooded with requests. And that's always the problem with this, is that you can come up with some cases where people say, well, obviously, this wasn't an undue hardship. But then there's going to be all the follow-on ones. And that's the slippery slope aspect of this. And so, I'm a big fan, obviously, of protecting religious rights, but there does have to be a balance out there when it comes to the question of employment and what any employee can demand be a circle drawn around them that cannot be touched. And so we'll see where the Supreme Court comes out on this. I think what we all agree on is that there ought to be something more definitive than the sort of vague language that exists now. What that is exactly, I think, is going to be a very tough thing for the court to sort through.
Thank you, Kim and Alicia. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back tomorrow with another edition of Potomac Watch.